Oh, maybe
sorry.
I should let you sit. Is affected to a large extent by the fact that sometimes certain, I think, certain sections of the political society or the civil society invite this in order to fight against others. And I wonder whether your research has examined this issue. Because this can be, I think to a large extent this can be, and of course there are cases in which foreign involvement is very successful. In Germany, Japan, the Reichman agreement and others. So the suggestion that it always creates a backlash, I'm not sure, or typically create a backlash is something that is interesting to examine. With respect to Doreen, this was very intriguing for me, but there is only one problem, I think.
Only once.
That I can see. And that is that civil resistance and civil involvement and chaotic kind of civil involvement has been a very common thing in the Middle Ages and even later. And my question is, why has it been only in 1871 with the Paris Commune that it has suddenly triggered this reaction? My suggestion is that perhaps humanitarian elements were also, I mean, it was a conjunction, if you want, of humanitarian, rise of humanitarianism and this fear that create a coalition. So I suggest to examine this issue, why only in 1871?
Do you want to answer and then we can move on, because we have time? Or do you want to take a few questions together? Oh, collect? Okay, that's great.
Okay, my name is Grit, and I am a nobody for this.
She was my former student, she's not a nobody. Okay.
But I have to introduce myself so you will understand the question. I've been living in the 13 years. I'm Israeli. I have a PhD in computer science, but this is not the issue at all. I've been living in Nigeria for the 10 years, and in the last 3 years I've been living in Colombia, in Bogota, and I'm doing in Nigeria the land reform of 9 states. I don't know, you didn't talk, the lady. And I'm sorry for my poor English because I'm speaking pidgin English, as you can understand. And in Colombia, I am not speaking English at all. I have been doing the land reform in Colombia that was the basis of Santos, Presidente Santos. He got his Nobel Prize over the peace process. And there is something that I really don't understand. And I'm not talking from law perspective. But I am living here. I'm a Nigerian citizen. I am a Colombian citizen. I am working with the Presidente or working with Bukhari, and never mind, the late, and I'm white, as you can see, and I am a woman, as you can see, and this is not a joke on those states. And I'm Israeli, and I don't hide it. They hired me because of it. And I remember until now, the first day that I came to Nigeria, and I started to talk about what we will do. And we are the Israelis, and we are not afraid. And he looked at me, the president of Nigeria, which has only 200 million people, and he is the best economy in Africa, they are not poor, and he said, don't be white. I didn't call you because you are white. We will do it our way, Nigerian way. And that is what I am doing it for the past 10 years. Because foreigner, I'm sorry, I don't know you, you don't know me, I'm sorry, I don't want any, that you will understand that I'm basically European and from the States, I'm sorry. And the States has a very issue with Nigeria, okay? You don't see Americans in Nigeria. When they come, you cannot, in my point of view, and again, I'm nothing, you cannot make a constitution from outside, sitting in Washington, sitting in Dublin or Edinburgh or whatever. You have to understand the people, their culture, and they have 157 tribes in Nigeria. How can you sit in London and make a constitution for places that you don't know? It's not. I'm sorry.
No, because I have a lot of questions, and I want people to comment.
I don't understand your point of view, madam. It is not working. Look, 1 minute, Nigeria is the only democracy, but you can call it democracy, that 8 years ago voted for
but we're sort of, I just want to get, there's a lot of people want to, if we have time, it's fine.
Very interesting.
No, it's right, but I just want to get questions.
I'm sorry.
No need to be apologize, and then we'll get back to this. So Mark, so Mark's the third, and then we'll get some more answers, and then we'll get some questions.
Two short questions. One, Hanni, which is half an observation, which is in the classical world, you have lots of people running around advising other nations to do constitutions. And I'm just wondering whether that's an interesting fact about the world, or whether there are interesting connections between the practices of the classical world. You also saw visitors writing constitutions, Rousseau, the Constitution of Poland, and the phenomena you're talking about, which is a more institutional advising. And for Doreen, by the way, these are three just terrific presentations. One thing, the slide you showed, the commune, they asked the separation of church and state, regulation of bakeries, and secular education. 40 years later, they get those things. So if politics had moved, so a lot of the demands of the Paris Commune become law 40 years later, why wouldn't they have sought to change the laws of war if, as you say, with, I think, powerful evidence, that in fact this is a reaction to the Paris Commune? I have questions too, but don't want to take up any.
Okay, so if you have time in the end, we'll get back to those who already asked the question, and we'll let them speak for the second time. Who wants to start?
Okay. So thanks for the questions. So in response to Alon's two questions, whether, I think you're absolutely right, whether the external advisors were invited by which part of the opposition or the government is very important. So at that very initial phase of the research so far, we are not detecting, but the next, I mean, of course, that's one of the questions. I don't have an answer to this issue right now. On the backlash issue, so first of all, I think it's important to distinguish between external advising and any other kind of international or external intervention. So in Japan, for example, the Americans did not advise the Japanese constitution, they wrote the Japanese constitution. It's a different, it's a different kind of power relationship. So our project focuses entirely on sort of voluntary kind of relationship. Yes, I have another paper that sort of classifies the different types of international intervention across sort of 4 categories, and this type of advising is deemed the least intervening or the least imposing kind of act of drafting a constitution, and then it really brings up questions about kind of level of access to local players and the relationship between the external institutions and the internal local players. And that's the main difference between, I think, this kind of very particular research topic and the more classical, I mean, historical cases of external advisors, which were always there historically. But here and maybe that goes also in response to your interesting question. The motivation for this project emerged exactly from this kind of critical perspective. I remember, I mean, we all know, I had a breakfast kind of meeting with someone, I'm not going to mention names, I would say he was American, who just returned from Libya and told me that he just returned from this amazing trip to Libya, you know, the post kind of uprising kind of period, and he advised the Libyan constitutions, and I asked him about, what, do you know anything about the local politics or anything? And obviously he didn't know that much. So that kind of brought up, I mean, we all know these people that walk around the world and advise based on sort of their knowledge of American federalism or whatever. So I wanted to write a paper kind of exactly discussing the ethics of external advisors, but then I found out that we don't know who are they? I mean, what's the scope of the phenomenon? So that was sort of the initial motivation. We first wanted to know more about what exactly is happening. I mean, the extent of this universe, and what exactly do they do, and then it's easier to criticize. I'm not sure, by the way. I'm actually less critical after kind of getting to know more nuances of this field and its scope. But yeah, that's the next paper.
Okay, thank you. So thank you for that question. So first, Alon, I think it's really a matter. This is a really historical question. So you're asking me why civilian disobedience or some kind of unrest in a period that is completely different, where armies are professional, the entire set of circumstances is so different, then it doesn't give rise to similar concerns. It's even not the same nation states that we're talking about here. The idea, the question is, why at this point of the 19th century, not later, not earlier, and so what triggered that particular process that isn't something that was perceived by the governing members of Prussia or France or Britain as something that they would be doing. So if you look at Geneva and St. Petersburg and earlier attempts, they were very resistant to such codification projects. So why then? And also the question about the humanitarian sensibilities, I think it's correct to say, and we're not challenging that these sensibilities were very much at present influential, part of the kind of spirit of the time, yet they were co-opted here. So they were used, it is as if these are humanitarian, it's as if this is a humanitarian project, it's packed as a humanitarian project, but it's actually not. And the way it's narrated later on, or imagined later on in a way of this kind of progressive narrative of triumph of humanitarian values is also very, from a legal point of view, is very problematic, because these codification projects were very limited in kind of protecting humanitarian values, if at all. So this tension between the narrative, or the discrepancy between the kind of heroic narrative and what the legal project was actually about had very serious ramifications on the ground. And the heroic narrative really played to the hands of those who didn't want a much more constrained army or greater protection to civilian populations. It's only in the 70s, with the additional protocol, that we get the real protection for civilians. So it would take almost 100 years of an imagined humanitarian project that doesn't really exist. So I think that's so in that sense, it's also a very, from the lawyerly perspective, it's important to see it that way for us. And Mark, your question is looking at these processes from within, and I think we saw late yesterday also that some of the political concerns that the drafters had for the weren't actually playing out because of the codification. So similarly, here some of the concerns of having of kind of legitimizing social unrest in times of war. What kind of protection do we have for those who don't surrender with their governments and actually rebel against their governments in times of war? That kind of or what do we do when communities resist occupation, which is also a way of thinking about the Paris Commune. All of that remains regulated or unregulated, depends how you see it, in the very kind of limited way that the codification. So even if some of the ideas of the Commune were then pushing through, it was not these very ideas that worried, I think, or not them alone. It was the more kind of deeper anarchical sentiment of not being governed by the governing, the fact that that whoever is the government surrenders in this pact with another head of state is not something they would abide by. That was what worried them, that you can't control these kind of democratization, nationalist processes once they are legitimated. And so that's what they, I think, wanted to curtail or tame. And not so, of course, these other ideas also worried them, but not as much. More as kind of resisting the order as it is, and not the particularities of that elements. But I think it's a very good idea to look at the kind of two processes, the kind of internal and international.
Consider that as part of the process, the progressive retelling of what happened, which has progressive consequences.
And also very non-progressive consequences. So for an international legal perspective, we have another paper that we wrote about the progressive narrative, and it's very problematic ramifications because it kind of had a chilling effect on codification processes that would harness or enhance greater protection for civilians in times of war, because as if this was already achieved, but it wasn't. So this kind of tension or discrepancy between laws in the books allegedly and the narrative of the laws in the books, that tension had very, I think, problematic implications as we go back. But perhaps I should look also at the more positive implications.
That wouldn't be us if we look at the positive things. Okay, so Eden, Eli, you want to, Eli, okay, Eden, Eli, Aviv, beseda? Okay, yeah.
Thank you so much. So I have two questions, one for Hanna and one for Doreen. So Hanna, in your presentation, there was like a slide with all of the countries that were assisted by outside forces, and there was a slide said international. So I was just wondering who that is. Like, is that the EU? Is that like the UN? Like it was on this slide of the countries that are used external. So I was just curious about that.
What's the question? Sorry, which organizations?
No, it says like you had all the states like.
Yeah, that's where only the top, the usual suspect.
Yeah, but then there was like international.
I think it was a mistake.
Okay.
Yes, I think it was a mistake.
Okay.
Good answer.
Yeah.
Okay.
And for Doreen, I think I want to push like a bit more about like what Alana said and your response now. I don't think that we should look at it as like a mutually exclusive kind of situation. It could have been the history of the whole just war theory movement, if we can call it a movement, and some humanitarian considerations that were kind of in the spirit of it, but also to have this motivation to narrow the implication and the civil society kind of like attempt to still the thunder and creating more humanitarian maybe and protection for civilians in a different way. So it could have been like this whole idea of states wanting to be stronger in the sense of deciding the laws, but also still having this understanding and motivation of reducing some of war hazards. And that's why I think that when we talk about humanitarian international law, it doesn't have to be precisely protecting every citizen, but we can also look in the prism of just mitigating that, like eliminating some of the harms that could occur to soldiers and whatsoever. So I just wanted to ask you about like the whole idea of the just war and how it goes with it.
More a comment. I really enjoyed Doreen's paper, and I just want to say it reminded me of just kind of these connections between war and codification and constitutions. Obviously not international law, but as an American historian, it reminded me of the Shays Rebellion in the United States, which was very similar. For those who don't know, uprising by former revolutionary soldiers right after the war. They're trying to take over the federal armory. It's because the Boston elites are trying to tax them in hard coinage, and it really is, I've been convinced lately after reading kind of different books, it really is one of the main impetuses for the framing of the American Constitution. And I think it touches on a lot of the issues you were talking about, including these separation. And one of the things that scared them most was that they couldn't raise an army fast enough.
And taxes later.
Yeah. And of course, but they couldn't raise the army fast enough to beat Shays. And so I just thought the arguments that you're making can even be broader than just international law.
Okay, so I'm joining Mark's praise to all the participants. It was really a very interesting workshop. Hanna, as I'm listening to you, I'm thinking about the ways that the non-Western world tries to influence the Western world. So you're focusing on all these organizations that are that their activity is open and we can somehow research their activity. But we are becoming more and more aware of the fact that the non-Western forces are using different methods, but to achieve purposes that are equivalent and a little bit different. So, for example, meddling with elections. Right? So you don't draft the constitution for the Western world, but you will try to influence who is in power. So actually the policies will follow the non-Western agenda, etc. So I'm thinking about, can we actually look at your project and zoom out of it and look at the kind of cross influences and how are they done and what are they trying to achieve? Okay, so writing constitutions and this is one way of doing it. Other ways of doing it is actually making sure the right people are in power. Okay, so this is I'm at least encouraging you to think about your project, even like juxtaposing this kind of activity with other activities of non-Western forces. Bini, first of all, congratulations, and we are all proud of you and we are behind you. I want to challenge you on two issues, or at least to hear your thoughts. So you mentioned that decisions in the district court and Supreme Court, when the court knows that this big Netanyahu case is coming, so even though the decisions you're mentioning are decisions that were issued before the Netanyahu case is going to be decided, it's obviously being written in the shadow of the Netanyahu case. So how can we really use them as independent, not related to Netanyahu cases, like precedents for Netanyahu? So that's one question. I wonder how you think about it. The other one is the comparative angle. So we know that the Netanyahu case is quite innovative from a comparative perspective, right? The whole regulation of the media and politicians and others have been careful not to actually taste the kind of waters we are tasting. So what do you think of that fact? The fact that we are actually experimenting something that is new even in comparative terms. How does it affect the way you are thinking about the cases?
Okay, so these are all the questions, and unfortunately we have 2 minutes. So I suggest each take 40 seconds so and answer, so we won't go over time. I have to teach, so I'm going to speed out of here.
Bini.
Yeah, Bini, we'll go Bini, Doreen, and Hanna, please.
Okay, so for the first question about the decision of Judge Limo Magdalene, honestly, I don't have a good or answer for that, but I can do something else. The decision of Magdalene is the district court in Tel-Aviv and the district court in Jerusalem. They are in the same level of this district court, so they know they can ignore of the decision because they're in the same level. About the arbiter that the Judge Yitzhak Amit wrote, this is a real problem, and I don't have a good answer for that. I honestly don't have the answer for that. About the regulation that we are not in a capability world, as far as I understand, as far as I see the 1,000 cases, the regulation is just one part of the puzzle. So I don't, even in that, I don't have a good question, and I have to think about that. But if we're looking at the indictment, okay, we're not only speaking about the regulation, we're speaking about a relationship. So part of that is the regulation. And if we will, for example, if we will look about Olmer, who was a former prime minister and accused in bribe, and he just got money. He didn't get a good coverage, and he didn't involve it in any regulation. And now we will take and we will do copy paste for that for the 1,000 cases. I think that it might be an answer for that, but I have to do another thing about it. I will do it with you.
Okay, so Hanna and Doreen graciously, gave up your right to respond to the comments, and maybe you can take it up in the short break. I also had questions, which I will not be able to ask. So thank you very much. It was fascinating.